I thought the letter was a mistake at first. The envelope looked official, but the number inside made no sense. $300. That's what the HOA claimed I owed. Not thousands. Not years of unpaid dues. Just $300, allegedly from a late fee accumulation tied to a landscaping violation I'd already disputed and corrected months earlier. I figured it would be another annoying notice, something I could resolve with a phone call. Then I read the next line. Intent to foreclose. My stomach dropped. Foreclose? Over $300? I immediately contacted the HOA management company. The representative sounded bored, almost rehearsed. She told me the amount had grown due to administrative processing and legal preparation. When I asked how $300 justified taking someone's home, she replied, "That's not our decision. It's policy." Policy. As if that word magically made it legal. I requested a breakdown of charges. She refused. I asked for proof of notice. She said it had already been sent. It hadn't. Then she ended the call. Within weeks, I was served court papers. The HOA was actually moving forward with foreclosure proceedings. Not a lien, not collections, full foreclosure. I couldn't believe it. I had never missed a mortgage payment. My property taxes were current. My only crime was questioning an HOA fine. The paperwork they filed was sloppy, full of vague references and copied language. Still, it was enough to drag me into court. The courtroom was tense the morning of the hearing. The HOA showed up with an attorney and 2 board members sitting smugly in the back. They avoided eye contact. I represented myself. I didn't have a fancy legal team, just documents, receipts, and state statutes printed and highlighted. When the judge took the bench, he immediately asked the HOA's attorney to explain the basis for foreclosure. The attorney confidently stated, unpaid assessments totaling $300. The judge paused. You could feel the shift in the room. The judge leaned forward and asked a simple question, are you seriously seeking foreclosure of a primary residence for $300? The HOA attorney tried to pivot, claiming fees, penalties, and authority under the bylaws. The judge stopped him mid-sentence. I didn't ask about bylaws. I asked about proportionality. That's when things started unraveling. The judge asked for proof of proper notice. They didn't have it. He asked when the homeowner was given a chance to dispute the charge. Silence. He asked whether state law was followed before initiating foreclosure. The attorney flipped through papers, visibly panicking. By the end of that exchange, the courtroom wasn't quiet anymore. People were whispering. The HOA board members looked nervous. The judge hadn't ruled yet, but it was clear this wasn't going the way they expected. And then the judge said something that changed everything. I want to see exactly how this amount became grounds for foreclosure. That's when the real chaos began. The judge didn't raise his voice. He didn't need to. He simply asked the HOA's attorney to walk the court through the math, step by step. Explain how $300 turned into a foreclosure filing. The attorney cleared his throat and began listing vague categories: administrative costs, legal review, enforcement actions. The judge stopped him again. I want numbers, not labels. That's when the hesitation started. The attorney flipped through his binder, buying time, but the confidence he walked in with was gone. I watched the HOA board members shift in their seats. One of them leaned toward the other and whispered something that made them both look down at the floor. The judge asked for the original violation notice. The attorney submitted a document dated after the supposed deadline to cure. The judge noticed immediately. So this notice was sent after the penalty period expired? The attorney tried to explain it as a clerical issue. The judge wasn't amused. He asked for proof of delivery. There was none. No certified mail. No signature. No acknowledgement. Just a generic template with my name typed in. Then came the billing records. The judge requested a breakdown of the fees that supposedly justified foreclosure. What was handed up looked more like a rough estimate than an accounting record. Lump sums. Rounded numbers. No timestamps. No invoices. The judge tapped the page with his pen and asked, asterisk, who authorized these charges? Asterisk, the attorney hesitated, then said the board did. The judge turned his attention to the board members and asked which one approved them. One pointed to the other. The other looked completely caught off guard. The judge asked a follow-up question that hit harder than any argument I could have made. Asterisk, does your association understand that foreclosure is considered an extreme remedy under state law? Asterisk, the attorney tried to respond, but the judge cut him off again. Asterisk, I'm not hearing any evidence that you treated it as such. Asterisk, he then asked whether any alternative collection methods were attempted before foreclosure. Payment plan. Mediation. Hearing. The attorney admitted none were offered. The courtroom got very quiet. At that point, the judge turned to me. He asked if I had attempted to resolve the issue before court. I handed over emails, call logs, and certified mail receipts, all showing I'd repeatedly requested clarification and a hearing. The judge read silently for a moment, then looked back at the HOA's table. Asterisk, you ignored every one of these? Asterisk, the attorney tried to argue that responses weren't required. The judge shook his head. Asterisk, they are when you're threatening someone's home. Asterisk, the HOA's case was unraveling in real time. The attorney asked for a brief recess to review documentation. The judge denied it. He then made a statement that changed the tone of the entire room. If this foreclosure proceeds without lawful justification, the court will consider sanctions. The board members froze. The attorney's face went pale. Suddenly, this wasn't about $300 anymore. And just when it looked like the HOA might retreat, the judge requested one final document, the one the HOA never expected to be asked for. The document the judge asked for was the HOA's foreclosure authorization vote. Not a summary. Not a statement from the attorney. The actual meeting record showing when and how the board approved taking someone's home. The HOA's attorney hesitated before admitting they didn't have it with them. The judge raised an eyebrow. Asterisk, then we'll hear from the board. Asterisk, that's when one of the board members was called forward and sworn in. The first board member spoke confidently at first. He testified that the board followed standard procedure and that foreclosure was a last resort. The judge asked him to explain what steps were taken before filing. The board member mentioned notices and fees but couldn't recall dates. When asked how many votes approved the foreclosure, he paused and said it was unanimous. The judge then asked for the meeting minutes. They were suddenly unavailable. The attorney tried to step in, but the judge waved him off. The second board member was less prepared. When sworn in, she admitted she never saw a full accounting of the charges. She thought the balance was much higher and assumed the legal team had already verified everything. When the judge asked if she knew the amount was only $300 at the time foreclosure was initiated, her answer was devastating. Asterisk, I didn't know it was that low. Asterisk, audible gasps came from the gallery. The first board member stared straight ahead, refusing to make eye contact. Then came the contradiction. The judge pointed out that one board member testified foreclosure was unanimously approved, while the other admitted she didn't know the amount or review the charges. Asterisk, so which is it? Asterisk, he asked. Silence. The judge leaned back and said calmly, Asterisk, you can't unanimously approve something you didn't understand. Asterisk, the HOA attorney objected. Overruled. The judge then asked the simplest question of the day. Asterisk, did the board ever vote to foreclose on this homeowner for $300? Asterisk, the first board member said yes. The second hesitated, then said she didn't recall any vote specifically about foreclosure, only legal action. The judge wrote something down. Slowly, deliberately. You could feel the weight of it. At that point, the judge addressed the attorney directly. Asterisk, your clients are now giving inconsistent testimony under oath. Asterisk, the attorney attempted to redirect, claiming confusion over terminology. The judge shut that down instantly. Asterisk, terminology doesn't explain away due process. Asterisk, he then reminded the board that inaccurate testimony carries consequences. Both board members suddenly looked far less confident than when the hearing began. The judge turned to me again and asked whether I had ever been invited to a hearing or meeting before foreclosure was filed. I answered no. I showed proof that the first notice I received was the foreclosure letter itself. The judge nodded and said something that made the HOA's attorney visibly flinch. That is a serious procedural failure. The judge announced that before ruling, he would review state foreclosure statutes applicable to homeowner associations. He told the HOA's attorney to remain available. Then he added one final line that sent a chill through the room. If the law is as clear as I believe it is, this court will not tolerate this conduct. Court was briefly recessed. And in that recess, the HOA realized they were no longer in control of the outcome. When court resumed, the judge returned with a thick stack of papers, printed statutes, not notes. He didn't ask the HOA's attorney to begin. He began himself. This matter hinges on whether the association followed state law before initiating foreclosure. His voice was calm, but firm. The HOA attorney straightened in his seat, already sensing where this was going. The judge stated the statute number and read directly from it, line by line, emphasizing each requirement with deliberate pauses. The law was clear. Before an HOA can foreclose, it must provide proper written notice, an opportunity to dispute the charge, a hearing before an impartial decision-maker, and evidence that foreclosure is a proportional remedy relative to the debt. The judge looked up and asked the attorney to identify where, in the record, any of those steps occurred. The attorney tried to point to internal policies. The judge stopped him immediately. Internal policy does not override statute. That line landed hard. The judge then addressed the issue of amount. He read another section stating that foreclosure should not be pursued for minor sums when reasonable alternatives exist. He asked the HOA whether a payment plan had been offered.
No.
Mediation.
No.
Demand letter with dispute rights.
No.
The judge shook his head. You skipped every safeguard the law requires. The board members looked stunned. One of them whispered to the attorney. It didn't help. Then the judge turned to the foreclosure filing itself. He pointed out that the HOA included projected legal fees that had not yet been incurred, inflating the balance to justify action. That is not a debt, he said. That is speculation. The attorney attempted to argue industry practice. The judge's response was blunt. Industry practice does not legalize misconduct. At that moment, it was obvious the court had lost patience. The judge compared the HOA's conduct to using a sledgehammer for a thumbtack. He stated that foreclosure is meant to be a last resort, not a pressure tactic. Then he looked directly at the board members and said, You don't get to gamble with someone's home because it's convenient. The room was completely silent. Even the court clerk stopped typing. Finally, the judge addressed the imbalance of power. He acknowledged that most homeowners don't have the resources or knowledge to fight foreclosure threats. He said courts exist to stop exactly this kind of abuse. Then he made it clear that the HOA's failure wasn't technical, it was fundamental. This association ignored the law, ignored due process, and ignored common sense. The judge closed his statute book and announced he was ready to rule. The HOA attorney asked to be heard one last time. The judge allowed it, briefly. The attorney claimed the HOA acted in good faith. The judge responded without hesitation. Good faith does not excuse unlawful action. He looked down at the case file, then back up at the room. The foreclosure is dismissed. But he wasn't finished. The judge didn't slam his gavel. He didn't need theatrics. His words carried enough weight. After dismissing the foreclosure, he addressed the remaining issues on the record. This court will not allow homeowner associations to weaponize foreclosure as a collection tactic. The HOA's attorney tried to pack up his files quietly. The judge stopped him. We're not done. The judge ruled that every fee associated with the foreclosure attempt was invalid. Legal costs, administrative charges, interest, all of it void. The balance was reduced back to the original disputed amount, then eliminated entirely due to procedural violations. The judge cited the HOA's failure to provide notice, hearing, and lawful escalation. You created this problem, he said, and now you will absorb the cost. Asterisk, the board members looked stunned. One of them put his head in his hands. Then came the part no one expected. The judge ordered the HOA to reimburse me for court costs and filing fees. He stated that while I represented myself, my time and expenses still mattered. He also issued a written warning to the association, noting that any future attempt to foreclose without strict compliance could result in sanctions or referral to the state oversight authority. The HOA attorney tried to object. Denied. Before closing the case, the judge addressed the board directly. You have a duty to understand the power you hold, he said. Asterisk, homes are not bargaining chips. Asterisk, he reminded them that ignorance of the law is not a defense, especially for governing bodies entrusted with people's property. The board members nodded silently. The confidence they walked in with was completely gone. Outside the courtroom, the HOA's attorney avoided reporters and left without comment. The board members exited separately. No eye contact. No statements. The foreclosure filing was officially erased from the record. My home was never at risk, but the message was clear. Abuse of authority has consequences. In the weeks that followed, things changed fast. The HOA quietly revised its enforcement policies. A new management company was hired. One board member resigned. Notices became detailed. Hearings were suddenly offered. Funny how quickly policy changes when a judge reads the law out loud. I didn't win because I was lucky. I won because I documented everything, challenged intimidation, and refused to be scared out of my own home over $300. If there's one lesson here, it's this: know your rights, because not everyone enforcing the rules does. And if your HOA ever threatens foreclosure over pocket change, make them prove it.